Hello, and welcome back to Strict Scrutiny, your podcast about the Supreme Court and the legal culture that surrounds it. We're your hosts. I'm Melissa Murray.
I'm Leah Littman.
And I'm Kate Shaw. We have now had a few days to step back from the term, which means we are ready, or as ready as we will ever be, for our term recap. So we're going to highlight some big term themes, share our takes on the biggest opinions of the year, and take a walk through some of the moments from the term that will forever be seared into our memories.
So one theme that I'd like to highlight just to get us started is this idea that the court giveth and the court taketh away. And by that, I mean the court sometimes gives us good stuff, sometimes takes it away in the same breath. And that often happens in tandem with the court highlighting really procedural issues that appear really wonky, but those procedural issues really mask underlying substantive questions that have really impactful consequences. So I'm just going to highlight a couple of these cases. Two of them were the e-cigarette cases. So there was the White Lion case in which the court upheld an FDA ruling on e-cigarettes. That was the giving. And then the court tooketh away, which is to say, in another case, it allowed those companies challenging FDA regs and rulings to find friendly litigants to bootstrap onto their litigations. And then they were able to file their lawsuits in friendlier circuits. And that, again, enabled them often to prevail against the FDA. So the case I just mentioned, RJR Vapor, essentially held that tobacco manufacturers can file outside of the DC circuit and the circuit in which they are incorporated if they can find some retailer or a gas station or basically anybody that sells e-cigarettes in a friendlier location. And the court did a similar kind of thing in Diamond Energy versus EPA with regard to standing, essentially allowing fuel manufacturers or fuel producers to jump in and challenge litigation against the EPA. So all of this, I think, is really concerning. And as in the birthright citizenship case, the court really focused on these narrow procedural questions, venue, standing, remedies that skirt these bigger, broader, more substantive questions.
So I would maybe generalize from that or go one step further in saying what the substantive motivation is behind these ostensibly procedural or technical issues. And that is giving a leg up to favored litigants and favored rights and erecting obstacles and burdens to disfavored litigants and disfavored rights. So you mentioned birthright citizenship and R.J. Reynolds. I would add to that JGG versus Trump, one of the initial Alien Enemies Act cases. So on birthright, the court chooses this existential challenge to our constitutional order, the project of Reconstruction, as the case to limit what remedies plaintiffs can get against the government. And in JGG, it says to the men who are at risk of being permanently sent to SCOTUS, the Salvadoran prison, that we now have a firsthand account of the torture the men will be subjected to there. It says to those men, file a habeas petition, a more challenging, difficult process than blocking a policy entirely under the APA. And then in RJ Reynolds, it tells Big Tobacco, you get to basically pick which federal court you file in, or contrast how the court exercised its discretion in Diamond Energy versus Birthright. In Diamond Energy, it revives a lawsuit by fuel producers against the EPA's approval of a California regulation, even though the Trump administration is considering at this very moment revoking said regulation, thereby potentially eliminating the need for litigation challenging it. So even though this whole issue is likely to be moot, the court chose to decide the case anyway. Then in Birthright, the court opts not to say anything about the merits and how wildly illegal the executive order is, creating this chaos and uncertainty about when and where it might go into effect. And this is what I took to be the BS that Justice Jackson talked about in her dissents in these cases. In Diamond, she talked openly about the perception of the court, quote, being overly sympathetic to corporate interests, end quote. And in Birthright, she says the court's decision will fall hardest on the, quote, poor, the uneducated, and the unpopular, those without the power to lawyer up.
Let me just add on to that, Leah. So I think Justice Barrett's opinion in Trump versus Casa is very much of a similar vein. And I want to focus specifically on the fact that she credited the administration's 30-day delay that had been baked into the initial EO, and that 30-day delay for the implementation of the EO was ostensibly so the government could devise guidance for implementing its obviously and flagrantly unconstitutional order. And she kind of credits that in the last part of it. I mean, like, again, talk about stacking the deck in favor of certain interests. Like, we know this is unconstitutional, but yet we're going to allow this 30-day delay to proceed so they can figure out how to do the unconstitutional thing more unconstitutionally. Like, it just doesn't make
Also,
any
you're
sense.
saying anything these guys say, the Trump administration says, gets credited and treated as law?
Yeah, I mean, I just have one more thought on that kind of part of the ruling in the birthright citizenship case that says, there is a 30-day delay that we are essentially going to just announce by fiat. It's part of the executive order, but we're saying, the administration has to wait to begin enforcing it. But guidance development can happen right now. And I just think a couple things about that. One, it does give me some pause with respect to all of these confident assertions that the executive order will clearly be deemed unlawful when the court addresses the merits. I mean, I still think that's very likely the case, but I think it is far from 100% certain. And I think this might be something of a tell. And I also think there is something profoundly corrosive to just kind of the general constitutional culture to say, executive branch lawyers, start devising how exactly is this going to go into effect? What should hospitals do when they are
devise how to violate the law.
Just figure it out. Figure out the mechanics of this egregious constitutional violation. I think it is appalling that the court does that. But there's one silver lining I think that should be noted, which is that once you have guidance, if they do it fast, then you have the possibility of a challenge under the Administrative Procedure Act, which you don't have in the context of just an executive order. So there is some sense in which the guidance might provide a hook for a different avenue for legal challenges.
Yeah, so I could go on forever about the substantive choices and vision reflected in the procedural rulings, but I'll just note one other pairing, which is Planned Parenthood and birthright. So in the former case, the Supreme Court says Medicaid beneficiaries and providers can't challenge a state's violation of federal law. On birthright, again, the court chooses an attack on multiracial democracy and the Reconstruction Amendments as a vehicle to limit remedies in civil rights cases. Then in Diamond, it adopts a generous theory of standing that makes it easier for fuel producers to sue. In the FDA and EPA cases, preserves the ability of corporate interests to pick where they sue. I feel like at this point, we are on theme number one, and I should warn our listeners that in the immortal words of Matt Damon playing Brett Kavanaugh on SNL, I'm going to start at an 11, and I'm going to take it up about a 15 real quick. Before we started recording, I read one of the more revealing garbage takes on the last term, and I haven't been able to come down from it.
Name a name.
Nope.
Name a name.
Nope. Leave it to the listener's imagination, and maybe I'll talk about it in the Friends of the Pod Discord.
Is this fuel more or less powerful than 3 Magnolia cupcakes? Just curious.
It's just different kinds of fuel.
Okay.
The Magnolia cupcakes make me a little cheery and chipper. This just makes me incandescent with rage.
Yeah. Okay. Well, I don't know if this is going to help.
I think I damaged my phone.
by throwing it across the room so hard. Okay. Well, I don't know if this is going to help, but I did want to add one more case here, which might ratchet things up further. But that is the shadow docket order DVD versus DHS. So there, the court may, just in terms of the kind of procedural and discretionary choices the court is constantly making and trying to conceal. So it made the decision to stay the careful work of the lower courts that had considered challenges to the administration's efforts to render individuals to third countries they had never been to, including South Sudan. The court put that lower court work on hold without saying a word about why. Now, we're just reading tea leaves, but it may be that there were some jurisdictional concerns about the court's ability to hear that case. That's the explanation Will Bode supplied for the court in a term roundup we did for the Times last week. But if that is the case, that would be another example of the phenomenon that Leah and Melissa, you're both identifying, which is the court, using these procedural shields to essentially reach the merits results that it wants to without actually taking responsibility for doing that.
And somehow that order in DVD became even more appalling when, on last Thursday evening, the Supreme Court granted the Trump administration's, quote, motion to clarify the Supreme Court's unreasoned, unclear order halting the trial court's injunction in the case. That had blocked the government from carrying out third country removals without providing due process. After the Supreme Court's unexplained, literally zero explanation order, the lower court, doing his darn best to figure out what's going on, determined that while the initial order/injunction wasn't in effect, a subsequent order still was, and that was the subsequent directive, a remedial order that had required the government to provide the men it shipped off to South Sudan without due process, in violation of the lower court's order to require the government to offer those men some due process and credible fear interviews before releasing them into the custody of South Sudan. On Thursday, the Supreme Court, quote, clarified that order was blocked too. What the government asked for, as Justice Sotomayor explained in a blistering dissent, is, quote, to send the 8 non-citizens it illegally removed from the United States from Djibouti to South Sudan, where they will be turned over to the local authorities without regard for the likelihood that they will face torture or death, end quote. Justice Kagan issued a short concurrence to the order, saying that while she disagreed and still disagrees with the Supreme Court's order staying the lower court's order, she doesn't think a remedial order can remain in effect to remedy an order that is itself no longer in effect. Which, I don't know, sounds plausible, but it's kind of treating what the Supreme Court did earlier in DVD with the same kind of presumption of regularity and lawfulness that this court unjustifiably provides the Trump administration. I recognize these obviously aren't totally the same thing, but still struck me as similar. Justice Sotomayor with Justice Jackson dissented, and did they? They wrote, quote, "Perhaps the majority hopes that, in light of its contentless stay order, the district court will simply give up on adjudicating this case. But if this court wishes to permit the government to flout the fundamental rights guaranteed by the Due Process Clause, it cannot avoid accountability for that lawlessness by tasking the lower courts with inventing a rationale." She also wrote, quote, "The court's continued refusal to justify its extraordinary decisions in this case, even as it faults lower courts for failing properly to divine their import, is indefensible. Today's order clarifies only one thing. Other litigants must follow the rules, but the administration has the Supreme Court on speed dial." End quote.
Okay, another theme of this term, I think, was all eyes on Amy.
Under Amy's eye, maybe?
No, his eye. We don't know.
Amy doesn't have her own eye.
That's correct.
Like in this particular milieu, she is definitely under his eye for these purposes. So at the end of the last term, Justice Barrett was on the receiving end of brickbats from conservatives who were incredibly disappointed that she displayed a modicum of restraint in certain cases. She was also, I think, in our view, weirdly and wrongly, celebrated by some liberals as the second coming of David Souter, which is to say they were wishcasting their fondest hopes and dreams for a 5-4 court onto Justice Barrett. Well, Justice Barrett took that personally, and in this particular term, she decided that Amy was going to Amy, which is to say that she made clear that she is a no more suitors conservative to her core. She is definitely with the boys, and not just with the boys. She's actually willing to beat up on her more junior Black female colleague, which has prompted MAGA world to celebrate Amy again some more, while also denouncing Justice Jackson as a quote-unquote DEI hire. I will just note that as of a few months ago, MAGA world was actually lambasting Justice Barrett as a quote-unquote DEI hire. So life comes at you fast.
It's almost like they're willing to accuse anyone of being a DEI hire so long as they are not a white male if they are doing things that they dislike or disfavor.
Dissent is the first D in DEI.
Correct. And I will just say, as between the Barrett opinion and the Jackson opinion, I really do just implore our listeners to read the two opinions and form your own judgment regarding who gets the better of it. Jackson's dissent, to my mind, clearly comes out on top. To pick up on Barrett, though, I assume she will continue to occasionally disappoint conservatives and rekindle a degree of hope, maybe what glimmers of mine remain. But her conservative bona fides should be safe for at least a little while. And I think that's not just because of her opinion for the court in Trump versus Casa, which, as we said in our emergency episode, is like her first really big opinion for the court. And boy, is it a doozy. Yeah. But also, I just want to kind of throw into the mix her track record in cases involving equality and liberty, which, you know, the birthright citizenship case obviously does as well, but ones that do more explicitly grapple with those things. So first, she wrote a truly extreme concurrence in the Scrutiny case, going out of her way to say that discrimination against trans people should not be subject to heightened scrutiny, in part because there hasn't been enough official state-sponsored discrimination against trans people. I mean, totally shocking factual claim, and also gratuitous to stake out a claim on the level of scrutiny which the majority resolves the case without deciding, and to do that while the ban on service by transgender individuals in the military is still pending, and while there are other cases involving pressing legal questions regarding the basic rights of transgender people before the lower courts and before the Supreme Court. So she went out of her way to say, this is how I think all those laws should be scrutinized. And I just actually want to mention one other case, which is her opinion last term for a 6-3 court in State versus Munoz, kind of under the radar. But this was this case that held there is no protectable liberty interest in living with your non-citizen spouse in the United States in a way that I think suggested a very cramped conception of constitutional liberty, at least if we're talking about anything but a paradigmatic heterosexual cis U.S. citizen marriage, which she probably does think the Constitution protects.
Well, maybe not in this particular milieu right now. So, I mean, Munoz takes on, I think, new contours right now. But I will just say that I think you're right to highlight those two cases. I think they really suggest her growth and her new level of comfort in her position, because I can still remember Justice Barrett in 2022 saying absolutely nothing in Dobbs, like, not even a word about a drop box where you could leave your baby. She had nothing to say. The sea witch had her tongue.
Yeah, she is going all in on Dobbs over and over, and I am personally over it. I do not find her interesting, and I implore people to stop trying to make Amy Barrett interesting. She will probably rule against the Trump administration in some tepid ways in some cases, but her right-wing views make her a reliable MAGA vote in most others, like most cases, period.
Strict Scrutiny is brought to you by Americans United for Separation of Church and State. You don't destroy 250 years of secular democracy without gutting precedent, shattering norms, and dropping a few billion. The same people and groups that backed Project 2025 are part of a larger shadow network that's relentlessly pushing to impose a Christian nationalist agenda on our laws and our lives. Church-state separation is a bulwark that blocks their agenda. One of the last bastions of church-state separation is our public school system. So they are pushing vouchers everywhere. They are arguing for religious public schools. Yes, you heard that right. Religious public schools. And they argued for it at the Supreme Court last term, which we talked about a lot on this podcast. If you're listening to us, you already see the writing on the wall. You know that we can and we must fight back. Join Americans United for Separation of Church and State and their growing movement, because church-state separation protects us all. You can learn more and get involved at au.org/crooked. This is an ad brought to you by BetterHelp. Workplace stress is now one of the top causes of declining mental health, with 61% of the global workforce experiencing higher than normal levels of stress. I'm just going to hypothesize that those individuals who work at 1 First Street are very much experiencing a high level of workplace stress, especially those in the 3-justice liberal minority. To battle stress, most of us can't wave goodbye to work. We can't say goodbye to our goblin colleagues on the other side of the court. But what we can do is start small with a focus on wellness. You can work out more. You can maybe spend some time touching grass. You can sit in the sun daily. You can walk on an incline. But all of those things aren't long-term solutions to your stress. Don't forget that in addition to all of those smaller fixes, therapy can help you navigate whatever challenges your workplace and the workday, or any day for that matter, can bring. Therapy has been great personally. A couple of years ago, I lost my mom, and I was really deep in my grief over her death. And it was really important for me and really helpful to have someone that I could talk to about my feelings, process some of that, find a way to cope with her loss and how I was going to move on from it. Therapy can give you positive coping skills for dealing with difficult people, can help you set boundaries with lots of individuals in your life, whether it's coworkers or family members. It can empower you to be the very best version of yourself. It's not just for those who've experienced a major trauma. It can be for any difficulty that you're experiencing in your life. And BetterHelp is prepared to help you launch your own therapy journey. BetterHelp has over 30,000 therapists. It's one of the largest online therapy platforms in the world, and it serves over 5 million people globally. And it works. BetterHelp has an App Store rating of 4.9 out of 5 based on over 1.7 million client reviews. And it's convenient. You can join a session with a therapist at the click of a button, which helps you fit therapy into your busy life. Plus, you can switch therapists at any time. As the largest online therapy provider in the world, BetterHelp can provide access to mental health professionals with a diverse variety of expertise. And our listeners get 10% off their first month at betterhelp.com/strict. That's betterhelp.com/strict.
So this next theme is the kind of big, the house is on fire energy that we are getting, both, energy and explicit warnings from both Justice Sotomayor and Justice Jackson. One thing I think is less than clear is whether it is the administration or the court that is to blame. I mean, maybe the obvious answer is why not both, but I just want to highlight a couple of writings on this theme. So first, Sotomayor, in her dissent in the DPD, case, that's the one where the court, granted this stay in the third country removals case, she says, quote, given its conduct in these proceedings, the government's posture resembles that of an arsonist. So here it's the government, right, starting the fire, who calls 911 to report firefighters for violating a local noise ordinance. In any event, the government has not established a likelihood of success on any of its arguments. That actually, I think, also well describes the government's conduct in the birthright citizenship case. And second, I want to quote Justice Jackson in the Social Security Administration versus AFSCME. This is the case involving Doge and Big Ball's access to Social Security Administration data. So she said there, quote, once again, this court dons its emergency responder gear, rushes to the scene, and uses its equitable power to fan the flames rather than extinguish them. So I think we have the administration starting fires and the majority on the court fanning flames rather than extinguishing them.
She's just so fucking good at writing so clearly with just super evocative turns of phrases that really capture the moment. And speaking of calling out bullshit, we wanted to remind people of this very memorable moment from Justice Jackson during the birthright citizenship argument, something that I think has really stuck with people, including us, in her description of the regime the Supreme Court might have just ushered in.
I understand. Let me just turn your attention to one other thing, because the real concern, I think, is that your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights. Justice Kagan says, let's assume, for the purpose of this, that you're wrong about the merits, that the government is not allowed to do this under the Constitution, and yet it seems to me that your argument says we get to keep on doing it until everyone who is potentially harmed by it figures out how to file a lawsuit, hire a lawyer, et cetera. And I don't understand how that is remotely consistent with the rule of law.
Okay, so coming out of that quote, let's maybe identify another theme, both from Trump versus Casa, but also more broadly from the term, which is the court siding with the Trump administration and against the district courts. So I think that's true about Trump v. Casa, kind of first and foremost on the court's merits docket, but the case just has to be discussed together with the court's disposition of cases on the shadow docket. So I know a lot of folks saw, and we have mentioned, the eye-popping statistic that political scientist Adam Bonica compiled a week or so ago, finding that from May 1st to June 23rd, federal district courts ruled against the Trump administration 94% of the time, and the Supreme Court sided with the Trump administration the same 94% of the time. Just like pretty stunning data. And look, there are some caveats to the data in that the administration only asked the Supreme Court to take up a small subset of the cases that they lost, ones where they thought they could make some kind of procedural argument that they could notch a win on. But it's still like that track record and this big win at Casa is hugely emboldening. And I think that you have already real evidence of that in that within, I think, a day of the Casa ruling in the birthright citizenship case, the administration filed its first appeal in one of the law firm executive order cases, the one involving the order targeting Perkins Coie. So they had been essentially just letting those losses lie. And they were all of a sudden like, oh, you know what? Maybe we'll take our chances at the Supreme Court. Might be able to get a win there.
Well, to that point, I just want to underscore the complete antipathy for lower court judges, both at the court within the administration. I think it was incredibly evident this term. On the court side, we saw in the oral argument in Calais and in Justice Alito's statements in the oral arguments from Trump versus Casa that these guys don't think that district court judges know what the fuck they're doing. Like Justice Alito was talking about district court judges as though they were monarchs of their own realm. And it's like, why don't you start with the man in the mirror? Why don't you ask that guy to make a change? Because that's where this all begins. And again, it is also worth noting that the two voices standing up for the district court judges against the administration and against this court are Justices Sotomayor and Jackson, who are the only two members of the court to have ever served as district court judges. And they have been vociferous in their defense of the juridical power of the lower federal courts. I will also highlight Justice Jackson's speech at the First Circuit Judicial Conference in Puerto Rico, where she talked explicitly about how the administration's rhetoric was putting district court judges in danger. And I will just note that it was pointed out to me that in addition to making those statements to a full audience of judges who gave her a standing ovation, Justice Jackson then had that speech and the coverage of it included on the Supreme Court's website. So she wants you to know this is what she thinks. And the antipathy was stunning this term.
Well, compare and contrast her rigorous, meaningful defense of the lower courts with the Chief Justice's meh kind of statements, in that direction. Kate, I agree with the limitations on the statistics you mentioned. I also think they are pretty eye-popping and say a lot. And one of the things they suggest to me is that the administration knows or has a pretty good sense of when the Supreme Court is with them, and that on a lot of things the Trump administration is doing, the Republican justices are with them. On term themes, I'm extra, not news to our listeners, so I couldn't stop myself at one, sorry. Like, if these guys don't have to, do law, I don't have to restrict myself to one #take on the term. So one, and I think this is related to what, you've both said, Kate and Melissa, but one is how the court is enabling lawlessness by giving the go-ahead to the administration and a big middle finger to the lower courts. Like, they respond sternly and quickly to the lower courts and then offer some, mild shrugs on Trump. Like, I don't care, do you? They come up with legal rules that basically say, yeah, there will be no consequences for violating the law. And I know we've gestured at this, but I think it's important to emphasize by pausing so many lower court orders, including ones the administration defied, they are adding cover and fire to the administration's rhetoric on the lower courts. The message they are sending to the Trump administration is that, yes, what the lower courts are doing is wrong. And when you send that to an administration who believes any judicial oversight is wrong and who is defying court orders, what do you think you're going to get? Again, in the case about perhaps the most egregious extreme lawlessness, birthright citizenship, they decided in picking what issues to weigh in on to say that the problem that warranted their attention and time is the lower courts. It is a law of lawlessness, a law for lawlessness. And to my mind, this court is an anti-Trump court. To them, the problem is people, institutions resisting Trump, not what Trump is doing.
I will chime in to say it's not even just that they're sending that message to the administration. It's that the administration is then broadcasting it to their supporters. And that is having a profound impact, negative impact on lower courts, the safety of lower court judges. It's incredibly irresponsible.
Completely agree. So my second theme is gerrymandered judging. So making up the law, a lot of bespoke law for the Republican Party. We've talked about this some already, and I wrote a short-term recap for Democracy Docket making this point, so I'll just quickly rattle through some of it. But in the Planned Parenthood Medicaid case, they make it harder to enforce rules about the availability of public benefits, the same programs the Republican Party is vitiating on major questions doctrine, a tool that might constrain what the executive branch can do. Brett Kavanaugh says this doesn't apply to foreign affairs, Trump's favorite kind of emergency or exception to invoke to justify emergency powers. On the First Amendment, porn is just different. In Trump versus Wilcox, our rule doesn't apply to the Federal Reserve Board. In Scrutiny, they revive precedent that legitimized sex discrimination. In Geduldig versus Aiello, they are ruling again and again for different constituencies of the Republican coalition that created and got us this court. The rich, corporate interests, the reactionary, right-wing Christian theocrats, and the strongman.
In this sense, I would say that the court is very much aligned with the administration, which rode to victory in 2024 on this kind of working class populism, affordability rhetoric. But since actually getting into office in January, this administration has been clear that they are beholden only to oligarchs and the mega rich. So you see this with the big, beautiful bill, the cuts to Medicaid that are contained within it, the efforts to limit services at VA hospitals, the cuts to hospital research and universities. And these are all programs that benefit working people, whether it is Medicaid recipients or veterans or the many people in red states who are employed by their local hospitals or their state university. So just to say this is not a populist court, and it is in service of an administration that's not really populist either.
Third, final theme, I promise, related to ones we've already talked about, what is law? Don't know her. These guys are making the law into a whole ass vibe, they're just hotboxing or freestyling, whatever you want to call it. The doctrines and reasoning they announce do not resemble anything I would recognize as law. They are not principles or rules that can be applied by the lower courts. It's just a bunch of mumbo jumbo that allows the court to do whatever the fuck it wants. Again, quick list. Scrutiny. This doesn't really feel like sex discrimination to us. Mahmoud Mahmoud. These books kind of give me the ick and make me feel like a bigot because I don't like gay people. Like, this is not judging because they only care about the interests on one side. In Mahmoud, the standard they adopt depends on whether the books are a normative message, it's a burden of the same character, it's an objective threat, not law, nationwide injunctions. Vibes are just different than the Bill of Peace. Like, in most of their opinions, it feels like you could pick out the sentence or sentences that contains the quote rule or quote reasoning, recite that sentence, and then say, the aristocrats, and you'd have like a pretty good joke. And the legal reasoning and rules announced in these cases are about as law-like as if Sam Alito was performing a rhythmic, artistic gymnastics dance routine like in Old School. It's just do the vibes seem off?
Do not do that to Will Ferrell.
Sorry. I'm sorry.
I will not stand for this Will Ferrell erasure.
It's not Will Ferrell erasure. It is reviving this image of Will Ferrell and
but
inviting
with Justice
people.
Alito's head on him, and no
one wants to visualize that.
Okay, sorry. I'm sorry. I've had to visualize and read a lot of things I didn't want to, so all's fair, all's fair. Okay, so those were, I think, the big themes we wanted to work through. I think there were some other assorted topics maybe to reflect on over the last term. One which we've really already gestured at, which is just the vision of Justice Jackson and her willingness to call out hypocrisy. We've mentioned her dissent in Diamond Energy, which was just remarkable, and talking about the perception that moneyed interests enjoy an easier road to relief in this court than ordinary citizens. So too was her epic, iconic footnote 12 in Stanley, calling bullshit on textualism. I can't and won't read it all now. Recommend to our listeners a track of Ellie Mistal reading it to the track of Ether. So the last line, I'll drop, really far from being insufficiently pliable, I think pure textualism is incessantly malleable. That's its primary problem. And indeed, it is certainly somehow always flexible enough to secure the majority's desired outcome.
So this was definitely the spiciest footnote of the term. It might even give Caroline Products footnote 4 a run for its money for the spiciest footnote of all time. But I just want to make clear, she is true to this game, but she's not new to this game. So let's go back to last term in Snyder, where Justice Jackson wrote a very spicy dissent where she observed that the tortured faux textualist reading of a public corruption statute was one that, quote, only this court could love.
Yes.
And she opened that opinion by noting that when public officials are on the grift, you could lose faith in your public institution. So she's never been here for the bullshit. And I kind of loved that she really stepped up the truth-telling this term, which I think helps explain the sharp rebuke from Justice Barrett in the Trump versus Casa opinion. I think Justice Barrett was not only commenting on Justice Jackson's very on-point dissent in the Casa case. I think she was actually speaking for the entire conservative supermajority that is probably more than a little PO'd that Justice Jackson continues to take them to the woodshed over and over again in her dissents. And I think they're really tired of her calling public attention to their absolute bullshit. I think that helps explain perhaps why Justice Barrett may have gotten this quite unusual assignment for such a junior justice. I think it's clear that the supermajority is not happy with what Justice Jackson is doing, but I also think the Chief Justice probably realizes that the optics are really fucking poor if he or one of the more senior male justices takes KBJ to the woodshed in an opinion. And so instead they enlisted Justice Barrett to write this decision and in the process to be the one to publicly chastise her colleague. So it looks maybe a little better, girl on girl crime, and they're more peers than anything else. But I think it would have looked really, really bad if the Chief Justice had been the one to do this.
That's super interesting.
Agree. It's a really interesting theory. I wonder what we make of, there was just this really interesting contrast in the Barrett majority opinion between the way she talked about the Sotomayor dissent, the principal dissent, which it is technically, but she kept saying that, like, that's a dissent that I disagree with, but I respect. And that other dissent, that's not even doing law. We're not going to take it seriously. I mean, it was really
not doing
striking.
Not doing law, you say. Did you read Brett's separate writing, girl?
Wait, so Kate, I think this is so interesting in view of the Jodi Kantor profile of Justice Barrett, where she mentioned specifically that there is some kind of friendship between Justice Sotomayor and Justice Barrett, and Justice
Oh,
Sotomayor
interesting.
has given gifts to Justice Barrett's daughter or whatnot. And it also reminds me of last term in the Andy Warhol case where Justice Sotomayor wrote a majority opinion and Justice Kagan issued a very stinging dissent. And I said on the pod then that it surprised me how barbed the dissent was, because I don't think anything Justice Sotomayor was saying was anything that Justice Ginsburg would not have said when she was the one writing those IP decisions. And I don't think Justice Kagan would have come at Justice Ginsburg in that way. And maybe there's a similar kind of thing here. Like maybe there's just a kind of grudging respect between Justice Barrett and Justice Sotomayor that just isn't there between Justice Barrett and Justice Jackson.
Yeah. I also just I really loved Jackson being as explicit in not just this term, but you're right to mention Snyder from last term about the deficiencies of textualism as a method. And I just think it's so refreshing. We're not just all going to embrace textualism and offer our sort of slight variations on it. I mean, I actually think she really does take text very seriously, but in context and not in isolation. And I just
Well, I mean, she's a district court judge. She used to be on the Sentencing Commission. She knows from text.
Completely. And she's just better at it. And she has no patience for the way they do it. And just made me wish I used to teach legislation as a law school class, and I don't teach it anymore, but I would love to teach some of Jackson's statutory cases if I were ever teaching that subject again. They're great.
Honestly, it's so refreshing, in part because I feel like at the various public law conferences or conversations I am part of, for the last however many years, even as a left-leaning progressive, Democrat, still saying you weren't a textualist put you in some sort of weird minority, like, oh, you're just not on board, you haven't gotten the message. And I feel like now, with her platform, she is providing so much support and ammo, and it is just wonderful to see and read.
Good.
So we also need to talk about Justice Kagan's appeasement energy. I don't know if maybe that's not the right thing to call it, but I will just note that there were a number of cases decided on a 7-2 fracture because Justice Kagan joined the conservatives. So RGR Vapor was one, Diamond Energy, Stanley versus City of Sanford. Any theories as to why Justice Kagan left Justices Sotomayor and Jackson out in the cold on these cases? And I will also note that these were some of the cases where Justice Jackson penned her most stinging dissents against the majority. What's going on here? Is Justice Kagan extracting compromises for her vote? I don't think her vote makes much of a difference with a 7-2 fracture. I mean, they're fine without her. What's going on here? Is this just sort of more appeasement? That's what Micah Schwartzman at UVA has called it in the context of the First Amendment. I'm confused.
I really don't know. I mean, Justice Kagan authored the non-delegation case, FCC versus Consumers Research. It's just hard to know, what is going on behind the scenes. And I think I've said this before, and it's something we've talked about, but it's so hard to know the internal dynamics at the court and the extent to which the Democratic appointees or any Democratic appointee feels like, if I peel off more or all the time, are these guys really going to go even full on crazier in more sets of cases? Like, they truly are enough snowflakes where that's not impossible for me to imagine. And I don't know how to strike the right balance. Diamond Energy, that case is one where Steve Vladek and I talked about this in the episode you all unfortunately had to miss. We are both sympathetic to broad theories of standing. So on the merits, I think they are probably right that there is standing. I think their decision to decide the case is appalling and is revealing of the kind of selectivity that Justice Jackson rightfully criticized them for, including on standing doctrine. But yeah, I don't know.
And I'll just say, I think she's a very kind of careful and tactical thinker and writer, and it is entirely possible that she, through the process of, draft revisions that circulate inside the court, she was able to extract some concessions where language she thought would be destructive in other areas of the law, and she was able to sort of smooth those over or get them actually taken out. So certainly, she may have made these one-off decisions that I think in the aggregate, it is a little hard to understand, but on an individual basis, actually may have been totally rational and helped blunt the negative force of some of these opinions.
Hear me out. I just worry that appeasement is not really a strategy here. I'm thinking back to Justice Breyer and Trinity Lutheran.
Yes.
That did not forestall the flood of absolute asshat decisions on the First Amendment that the court produced. And I'm also thinking of her joining the dissent in Ramos. When was that? Back in 2019. And I understood then, I think she telegraphed pretty clearly that she was joining them in order to make a point about stare decisis and the continuing vitality of Apodaca versus Oregon, a decision decided in 1973, the same year as another embattled decision. And that still did not forestall what happened in Dobbs.
It didn't forestall it. You know, as we've kind of speculated before, it might delay some of the impending doom.
We got a good 3 years out of that.
3 more years of the Establishment Clause. Again, I don't know. And, you know, I am also super skeptical of the appeasement strategy. It is not obviously where I lean. And I do think this difference in the justice's posture relates to another thing that was said on the episode with Steve that I was mentioning. And that's something Mike Sachs said, which is Justice Jackson as the model of the post-Dobbs justice who recognizes that appeasement fails. And that is not the strategy. You need to construct and build something new and advocate boldly for an alternative vision.
Let me say what I'm going to say what I mean plainly then. I think this appeasement strategy in this particular moment where it's a 6-3 court and there are 2 women of color among that minority and you are the third person. And I think when you depart, even on these cases that look not so consequential but are actually quite consequential, you leave the other 2 open to tons of charges from the conservatives about the stupidity, the lawlessness of their reasoning, when if you join them, you could insulate some of that talk. And I think I'm not sure that the appeasement is worth what you're losing.
That's a super great and important point, because I feel like in some ways what you're saying is that Justice Kagan might be ignoring some important context, right, in which the court is deciding cases, in the same way that the Republican justices in the supermajority ignore the context of the Trump administration, right? And like not situating your decisions in the moment we are in, right, is...
I wouldn't say those are comparable, right?
No.
Yeah. But for sure, like there are real costs involved. And I think, Melissa, you highlighted those really, really well. Okay, so another thing I want to pause over. So we've talked obviously about Kagan and Sotomayor and Jackson and Barrett. Let's talk about the chief a little bit. And I want to maybe raise a couple of things. One, kind of the chief's role and how central that is in the court's orientation toward Trump in this past term. So at the end of the term, the Chief Justice offered some remarks at a judicial conference. Quote, "If you have somebody who's expressing a high degree of hostility to the court on whatever basis, the danger, of course, is somebody might pick up on that. And we have had, of course, serious threats of violence and murder of judges just simply for doing their work." So he's so close to actually identifying the problem, and yet does not seem able to actually internalize that Donald Trump is the guy in the hot dog suit, or maybe John Roberts
the
is.
Chief
or
Justice
maybe
is like the Chief
It's
Justice
me. Hi,
is
I'm the problem.
begging
It's me.
for the guy in the hot dog suit meme. Like, sir, we're all trying to find the guy who did this. Like,
Well,
this
it's
is
not. Yeah.
Well, no,
Trump is a big part of it.
Yes, but this is some of what I'm talking about with the anti-Trump court. The timing of this signals don't call us Supreme Court out for our complicity in what the Trump administration is doing. He's signaling that's just like when Donald Trump posts pictures of judges and their families and invites death threats against them.
I just don't even know if he is able to grasp that Donald Trump is as culpable as he is. Maybe he is. I'm not sure.
Or that he is as culpable as
he is. Yeah.
The Leah point is that Roberts is culpable. I'm just not even sure he realizes about Trump either. I don't think he thinks either of them is responsible. But I also just kind of wanted to pose this question, which is, what do we think about Roberts in this moment and the Roberts court? So remember, we've now been doing this podcast for over 6 years. So I remember after Dobbs, it really felt, and we really talked about Roberts having lost control of his court, right? So he doesn't join the majority opinion that overrules Roe and Casey. It doesn't feel like they need him or care what he would like the court to do, how fast, how radical, any of it. And I just wonder whether in the wake of the immunity opinion and his rate of 95% presence in the majority in opinions this term. I mean, this is really, really high. He was in the majority in almost every case. I guess, is it, again, his court in more than just name? What do you guys think?
We definitely talked about this last term with the Clean Water Act case. I mean, he gave Justice Alito like the most parsimonious docket to write last year. And I think that was intentional, sort of like, I'm the captain. I'm really the captain and you're not, and get it together. I think he has been wresting control back from the hardcore conservative bloc. And I say hardcore conservative bloc advisedly because I think to call them hardcore and to take Roberts out of it is to suggest how far to the right the court really has moved. This is his court. I mean, I think he's making decisions. Some of them I think are really strategic. As I said, with the choice of Justice Barrett for Trump versus Casa, I think he allowed her to carry a lot of water and take a lot of the heat for the whole conservative supermajority.
Yeah, I think it is his court. And I think it's his court in part because he is on board with a lot of what they are doing. And so they are traveling together, and he is authoring some of the worst decisions in those respects.
So let's cover a bunch of additional kind of smaller themes. One, foreign law in the last term, I think, played a pretty interesting role. So once upon a time, for our younger listeners, it was anathema for conservative justices to consider or cite foreign law. Our Constitution was all that mattered, and it was something I would say akin to lawless to even consider the practices or legal regimes of peer nations in deciding what the Constitution or laws in the United States meant or required. So an example of that is Justice Scalia's absolute hissy fit over the nod to foreign law in Justice Kennedy's majority opinion in the 2003 case Lawrence versus Texas. So the court then, 20 plus years ago, was firmly of the view that foreign law or citations, even in passing to it, were bad for limiting the government's ability to criminalize consensual sex between adults. But all of a sudden in 2025, if you read Justice Alito's opinion in Scrutiny, it is totally fine to cite foreign law if the goal is to uphold the government's ability to dictate medical treatment for other people's children.
I think that's a really good point. Foreign law is great when it allows us to get to our desired outcome. It's almost like we're an outcome determinative court doing vibes, not law, but who said that? I'll say the other point that we ought to focus on a little bit is the way in which these justices seem to have a really hard time figuring out their own docket. So I thought it was really telling and very on brand for this group that I think, as Leah points out, has struggled with this law thing quite mightily over the last couple of years. They really could not figure out why they had taken some of these cases. So there were 3 digs this term. A dig is a situation where the court decides that certiorari was improvidently granted and the case is subsequently dismissed. There might be lots of reasons why you would dig a case. Maybe you've decided on reflection that this is an improper vehicle for deciding the issue at stake. Maybe the facts aren't sufficiently well developed. Either way, a dig kind of suggests that maybe you should have done a little more upfront reading. And the court did a few digs last term. There was the very famous dig in the Moyle case with the conflict between the federal law EMTALA and the Idaho abortion law. And this term, they digged 3 other cases. So there was the NVIDIA case that they digged. There was also Facebook versus Amalgamated Bank, another dig. And then the LabCorp case, which was also digged. And it just, again, we've talked about this before on the podcast. The fact that they figure out later that maybe these aren't good cases to be deciding suggests that at least some portion of the court is in such a rush to decide certain issues that they just give their votes for cert. They get the 4, they put it on the docket, and then they're like, oh, wait a minute, this really is not what we should be doing. And that's one of, I think, the dangers of a supermajority, where you don't have to be really considered, where you don't have to think about where your votes are coming from on final review, and you can just take stuff. And they have been taking stuff.
Yeah. Another theme to highlight is selective stare decisis. So I think it's pretty clear that stare decisis is still for suckers, just not all the time, right? Some of the time. So let's play a clip from kind of a smaller case from this term, Royal Canin, because it has Justice Sotomayor once again trying to tell us.
Do you think that courts of appeals read our decisions differently than we may? I mean, I was on a court of appeals for 15 years. If I saw a strong dictum in a Supreme Court decision, I would very likely just salute and move on. But here, we have more of an obligation. It depends, Justice Sotomayor.
All right. Just to take an inventory so we're all clear about where we stand here, stare decisis is apparently okay in the context of Yoder versus Wisconsin, allowing the Amish to opt out of compulsory high school education. Geduldig versus Aiello, where it is clear that any distinction based on pregnancy is not a sex-based distinction for purposes of the Constitution, and any case that triggers Justice Alito's feelings. Those are all fine for stare decisis.
Yes.
Are we
stare
good?
decisis is apparently not for Employment Division versus Smith, which says neutral, generally applicable laws that burden religious practices are constitutional. Also not for the court's previous First Amendment cases about restrictions on non-obscene pornography, which had applied strict scrutiny, not intermediate scrutiny. Also Talevsky on the spending clause, which said you can enforce spending clause power legislation through the general civil rights statute a mere 2 years ago. Also, all of the cases involving nationwide injunctions against the Biden and Obama administrations, no stare decisis there.
Correct. And stare decisis is very much TBD for Wong Kim Ark, the Supreme Court case that confirms that the first sentence of the 14th Amendment means what it says, which is persons who are born in the United States are citizens, regardless of the status of their parents. Also TBD, the cases the court has previously decided upholding the constitutionality of the Voting Rights Act. We don't exactly know what the court is going to ask the parties to brief in the Voting Rights Act case, Louisiana versus Calais, which will be re-argued next term, but it will not be good, whatever it is. The remaining parts of Buckley versus Vallejo, the 1976 opinion, in which the court did a bunch of things, but in part found that the Constitution did permit some regulation of campaign finance. We will see if that endures after next term. And maybe just for good measure, all Warren Court decisions. TBD, if any of them are still good law.
Yep.
We'll find out. Really keeping my fingers crossed for Brown.
But, I mean, I would say too soon, but
if they overrule Brown, they don't get to say Brown actually forbids efforts at integration,
That's
which
true.
they love to do. So
That's the
keep it for
upside
that.
of Brown. Yeah, that is the upside.
Yeah.
Great point.
Strict Scrutiny is brought to you by Mint Mobile. I know that so many of you are having a hot Strict Scrutiny summer right now, but you know the one thing that doesn't belong in your epic summer plans? Getting burned by your old wireless bill. So while you're planning your beach trips, your barbecues, your 3-day weekends where you're listening to Strict Scrutiny on repeat, your wireless bill should be the last thing that is holding you back. That's why so many people are making the switch to Mint Mobile. With Mint, you can get the coverage and speed that you're used to, but for way less money. And for a limited time, Mint Mobile is offering 3 months of unlimited premium wireless service for $15 a month. So while your friends are sweating over data overages and surprise charges, you will be chilling, literally and financially. So say goodbye to your overpriced wireless plans, jaw-dropping monthly bills, and unexpected overages, because Mint Mobile is here to rescue you. All plans come with high-speed data and unlimited talk and text that's delivered on the nation's largest 5G network. You can use your own phone with any Mint Mobile plan and bring your phone number along with all of your existing contacts. So ditch overpriced wireless and get 3 months of unlimited service from Mint Mobile for $15 a month. We've seen right here at Crooked headquarters just how attractive the Mint Mobile deal is. Our Crooked staffer Nina ditched her old wireless plan for Mint Mobile, and she says that she is saving $40 a month and that she loves this service, and she recommends it to everyone she knows. So don't take my word for it. Take Nina's. Get on over to Mint Mobile and sign up. This year, you don't have to break a sweat and you don't have to break the bank. Have your hot Strict Scrutiny summer with this new customer offer and your 3-month unlimited wireless plan for just $15 a month at mintmobile.com/strict. That's mintmobile.com/strict. An upfront payment of $45 is required. That's equivalent to $15 a month. Limited time new customer offer for the first 3 months only. Speeds may be slow, above 35 gigabytes on the unlimited plan. Taxes and fees are extra. See Mint Mobile for all details. Strict Scrutiny is brought to you by Stamps.com. You know how easy it is for your whole day to get hijacked by tedious but minuscule tasks? Like going to run an errand, picking up this, picking up that. All of it leaves you with little time to focus on what you love and what you do best. So are there meetings that could have been an email? Definitely. Do quick errands turn into an all-day event all the time? If you're a realtor, a lawyer, an accountant, or any profession that requires a lot of mailing or shipping, you don't have time to be a postage expert or to stand in line to drop off letters and packages, which is where Stamps.com comes in. Stamps.com gives you a chance to focus your time on what you do best. They take all of those little errands, the running to the post office, the picking up the stamps, the mailing and shipping of the package, and they do it all for you. Stamps.com gives you the chance to focus your time. It prints the stamps, it prints the shipping labels, it can do certified mail forms in seconds, and you can schedule free package pickups all from one place. All of this is for up to 89% off what the U.S. Postal Service, UPS, and other carriers would charge you. For more than 28 years, Stamps.com has been doing more than just small business mailings. It handles all of your mailing and shipping needs wherever, whenever. It seamlessly connects with every major marketplace and shopping cart if you sell your products online, and you can access all of the USPS and UPS services you need to run your business right from your computer or phone, anytime, day or night. No lines, no traffic, no waiting, no wasting time. Stamps.com provides you with the flexibility to do all of your mailing and shipping needs in one easy, all-in-one solution. You can take care of mailing and shipping wherever you are, even on the go, with the Stamps.com mobile app. All you need is a computer and a printer. They even send you a free scale. You can schedule pickups through your Stamps.com dashboard. You can see your cheapest and fastest shipping options from different carriers. So no more tedious postage math. And it's also easy to get the best rate on shipping from Stamps.com's Rate Advisor. So there's no more tedious postage math. You can just go to Rate Advisor and it helps you calculate the best shipping rates fast. You can get rates that you won't see anywhere else, like up to 89% off what USPS and UPS charge. So don't waste time worrying about being a postage expert or standing in line to drop off letters and packages. Let Stamps.com do what they do best so you can do what you do better. Go to Stamps.com/strict to sign up for a special offer. No contract. You can cancel anytime. That's Stamps.com/strict.
Okay, so we want to highlight a handful of notable moments from the last year. One, we've talked about this before, but it deserves one more turn. Edith Jones coming for our friend Steve Vladeck at a FedSoc conference. We are not going to force you to rehear that moment. We will just remind you that a federal judge came to a panel with a manila folder containing printouts of Steve's tweets criticizing single judge divisions. And she proceeded to read Steve's quote mean, weren't even that mean, tweets, and accuse him and not Matthew Kacsmaryk of being the problem. This was a perfect indication of a judicial temperament. Give her a promotion stat.
Edith Jones, read my social media posts if Steve's trigger you challenge.
We should also say, as we reflect upon the term, that we are very grateful for all of you, the Strict Scrutiny fandom. You keep us going in what has been some very grim times this term. But I just want to highlight that it is not often that we get a rave review from One First Street, a supreme review, if you will, which is why we were a little surprised but very gratified to read Justice Alito's majority opinion in Mahmoud versus Taylor. And it wasn't just Justice Alito's utter disregard for precedent other than Yoder that surprised us in that decision. In fact, it didn't really surprise us at all because Justice Alito. Instead, what surprised us was that Justice Alito acknowledged publicly in writing that this podcast, Strict Scrutiny, is, in his words, appropriate. Let me read the quote. Justice Alito said, and again, I'm quoting, "Strict scrutiny is appropriate." Now, obviously, that is not necessarily the most overwhelming and enthusiastic endorsement, But we know that Justice Alito is not one to gush. So given that he is often a little bit stingy with his praise, and because we know he is deep down a friend of the pod, we're going to take it as a win and maybe make some t-shirts with it. So thank you, Justice Alito. You heard it here, folks. Strict scrutiny is appropriate.
It is his version of a 5-star review, I'm quite sure.
You don't need to prove your age before listening. We are appropriate. We get strict scrutiny all the time.
Oh, careful. Don't give him any ideas. Age verification. What other verification for downloading our podcast? Anyway. Okay. So we also wanted to highlight some highlights, lowlights, memorable moments from oral arguments. And let's start with a moment from Garland versus Vanderstock, which was a case about ghost guns and whether federal law restricted their sale. I mean, yes, you heard me right. That case was this term, which really kind of underscores how much this last year has actually been 1 million years. So
a
let's play the
millennia.
clip.
A millennia.
Yeah.
Paragraph
No,
B.
I want to stick with the definition of weapon for just a second.
Oh, sure.
I'm going to show you. Here's a blank pad, and here's a pen. All right? Is this a grocery list?
I don't think that that's a grocery list, but the reason for that is because there are a lot of things you could use those products for to create something other than a grocery list.
All right,
and so it's not like they're...
If I show you, I put out on a counter some eggs, some chopped up ham, some chopped up pepper and onions. Is that a Western omelet?
No, because again, those items have well-known other uses to become something other than an omelet. The key difference here is that these weapon parts kits are designed and intended to be used as instruments of combat, and they have no other conceivable use. I actually had the experience of putting one of these kits together, and it's just like what the record shows. There are usually only a couple of steps. The first thing that most of the kits require is drilling the holes. Usually it's 6 holes, and you do it with the jig.
That case was argued before Luigi Mangione. And I'm just going to say, I think Luigi Mangione may have been a deciding factor in this court concluding that ghost guns fall within the ambit of the Firearm Act. I'm not even joking. Like, Elizabeth Krelager did an amazing job, but I think the realpolitik of that moment may also have been very determinative. That clip also highlights that earlier this year, we had a different SG, Elizabeth Krelager. The transition from her to acting Solicitor General Sarah Harris was also kind of an interesting one. But we then got another transition to John Sauer. And all of that happened in just a single term, a term of 3 SGs. It just boggles the mind, really.
So all that happened in a single term, but John Sauer's ascent happened in this calendar year, as did the TikTok argument. That was in 2025. So was the Supreme Court's 5-4 decision rejecting Trump's effort to block his sentencing in the New York hush money case. That was January of 2025, launching a million takes about Amy Coney Barrett as our savior. But also, I feel like I've aged 40 years, and all that was January.
So maybe looking back on this millennia, let's do a quick round of roses and thorns.
Okay, so here's one rose or maybe bullet dodge, which was the court's decision in AJT declining to impose a heightened standard on students with disabilities raising claims under the ADA and the Rehab Act. There is, of course, an ominous Thomas concurrence thorn, which raises questions about Congress's constitutional authority to impose accommodation obligations on schools at all. But the majority opinion definitely was, I think, a rose. Also a rose in the court. Again, this is like how far we have fallen that these are roses, but they are given where we are. The court declined to further upend administrative law and further hobble administrative agencies in both Braidwood about the composition of the Preventative Services Task Force and FCC versus Consumers Research, which was about the FCC's Universal Service Scheme and the non-delegation doctrine. Tiny little rose I will note is that the dissent in Scrutiny cited an amicus brief we've mentioned on the pod, authored by my dear friend Isa Kohler-Hausman and my awesome colleague Amanda Shaynor. And it was, a powerful enough discussion in the Sotomayor dissent that the majority tried, albeit unconvincingly, to respond to that argument.
I'm going to be brief here because although this term was long, it was consistent. And I find as the Rose here, the fact that every lower court that encountered the birthright citizenship EO was like, yeah, that's obviously unconstitutional. And they did it all in under 30 minutes. I'm exaggerating, but it felt like that. I also appreciate the lower courts essentially holding the line on these EOs eliminating the Department of Education, firing federal workers. Like, yes, like all of these things really require congressional intervention. And we should, again, highlight that. The separation of powers things is a real thing. The thorn here, I think, is this administration, this court that is facilitating this administration, maybe even effectuating and facilitating this administration in equal measure. And of course, the cadre of oligarchs who apparently own us.
Well, also the appearance of all of those oligarchs at the inauguration was just
a lot.
Its own thing. So in my roses and thorns, I guess all of these are going to be roses/thorns. So one is Justice Kavanaugh's concurrence in Trump versus Casa. Steve Vladeck did a phenomenal one-first piece called The New Judicial Supremacy on it, basically exposing the extent to which Brett Kavanaugh, while ostensibly being kind of a formalist in the majority opinion, Justice Barrett's being an anti-formalist in his separate writing, also assuredly saying, I can and will solve everything, even though the Supreme Court has never bothered to explain most of what they do on the shadow docket, and insisting that the court would be in a position to provide a uniform interim rule, even though they declined to do so in this case. So like rose/thorn, thorn in just its grotesque obliviousness, rose in that it basically proves everything I've ever said about Brett Kavanaugh is right. Another rose/thorn, Justice Jackson's dissent in Department of Education versus California. This was one of the dissents from one of the shadow docket orders where she kind of broke the fourth wall and accused the court, of giving the Trump administration an early win when they were ultimately going to lose on the merits for some sake of appearances that I just found fascinating. Thorn in that it was a dissent, same rose/thorn energy to Justice Kagan's dissent in Trump versus Wilcox, in which the Supreme Court basically overruled Humphrey's executor on the shadow docket. There she accused the court of favoring this president over our precedents, of creating a bespoke Fed exception, and saying the order allows the president to overrule Humphrey's by fiat. So those are my roses/thorns.
When you said that the Brett Kavanaugh was a formalist in the majority and then not a formalist in his own concurrence, it reminded me of when Strom Thurmond passed away and they noted that he had fathered an African-American child out of wedlock, and the newspaper report that I read called him segregationist by day, integrationist by night.
Oh my God. Oh my God. Schrodinger's formalism is what I'll call this, I think, because I can't top that descriptor. Good. So I guess some additional news to note that's kind of related to fallout from this, whatever it is we just concluded. So one is some fallout from the court's opinion in Scrutiny. In particular, on a recent orders list, the court did some GVRs, grant, vacate, and remand. So what those do is they vacate some lower court opinions and remand for the lower court to reconsider their decision in light of a Supreme Court opinion. And this was notable to me because after the chief said in the majority opinion in Scrutiny that the case wasn't about laws that discriminated against trans people, because the Tennessee law didn't discriminate against trans people and was just about a medical procedure, wink, the court GVR'd a ton of cases about laws that did discriminate against trans people, weren't just about healthcare, and told the lower courts rethink this in light of Scrutiny, almost as if the limits in Scrutiny weren't real and were just some soothing BS. Add to that the court's rejection of the parental rights challenge in Scrutiny. They opted not to hear a parental rights challenge to laws banning gender-affirming care for trans minors. Chris Geidner had a phenomenal piece at Law Dork about this. SCOTUS's parental rights message: protect anti-LGBTQ views, ignore LGBTQ people. This is part of why I don't trust these asshats on birthright, or just one of the reasons. They said Scrutiny was just about a healthcare ban that didn't discriminate against trans people or on the basis of gender identity. Then they go ahead and ask the lower courts to take another look at a bunch of other laws outside the healthcare context that do discriminate against trans people. And on last Thursday's order list in Montana versus Planned Parenthood, Samuel Alito, the author of Dobbs, wrote with Justice Thomas that maybe the Constitution gives parents parents a constitutional right to prohibit their children from getting an abortion where state law allows it, i.e. the Constitution overrides some democratic political choices that the political democratic process might make about abortion. So much for leaving the question about the availability of abortion access to the political process. Also, the court just agreed to take up next term the constitutionality of state laws that exclude trans women and trans girls from participating in women's and girls' sports. Not surprising, given the eagerness of Justices Barrett, Alito, and Thomas to address the question of whether trans people constitute a protected class. But still, add to this a recent 11th Circuit decision that held that a transgender school teacher had no First Amendment right to refer to herself with she, her pronouns when Florida law prohibits her from doing so. The court reasoned that when the teacher is in front of the classroom and engaging with students, she is a government speaker and representative of the government, and accordingly can be required to misgender herself.
Obviously, this outcome would have been completely different if the trans teacher were also the school football coach who articulated her pronouns on the 50-yard line at the conclusion of each game, because then she would not be a public employee.
I see. The 11th Circuit did reject an analogy to Kennedy versus Bremerton School District in this case, because religion/trans people, line up this 11th Circuit decision with cases in other courts of appeals that say teachers have a First Amendment right to misgender students, i.e. they cannot be forced to address trans students with their correct pronouns. And, ladies and gentlemen and non-binary listeners, what we have is a doctrine that says the First Amendment just protects your right to misgender people. It doesn't protect your right to use correct pronouns. It is just the perfect encapsulation of lawlessness and how they are fashioning the law just to require the Republican Party's views.
Hold up your book. Always be closing. Okay, good.
This is my book, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes, if you haven't heard me talk about it. The New York Times Book Review recommended it, even though they called my humor somewhat cringe. I think I'm funny, though.
So do we. So do our
do.
listeners.
Okay. On a less funny, more somber note, Kilmar Abrego-Garcia, the man who was wrongfully expelled to El Salvador because of a clerical error, has filed an amended complaint in his case in the District of Maryland. The complaint asks the court to return Abrego-Garcia to Maryland and restore the status quo that was in place before he was expelled to El Salvador. And this is the really important part, I think. The amended complaint now contains allegations about what actually happened to Mr. Abrego-Garcia while he was in SCOTUS, the Salvadoran mega prison where he and all of the other individuals who were deported to El Salvador were held. To our knowledge, Abrego-Garcia is the first person released from SCOTUS, so this would mean that this amended complaint is the first-person testimony from someone who is able to actually account for what he witnessed happening in SCOTUS. And I'll just be very clear here. What he alleges in the amended complaint is absolutely horrifying and shocking.
It made me ill reading it. So this is your heads up, listeners. We are going to recount some of what is in the amended complaint.
Yeah, because if you haven't actually had a chance to read it, I think it's important for us to describe some of its contents. So the complaint describes how, upon arriving at SCOTUS, Abrego-Garcia was repeatedly struck by officers when he attempted to raise his head. He was told, quote, "Welcome to SCOTUS. Whoever enters here doesn't leave." He was forced to strip. He was beaten more. He was struck in the head. Frog marched to a cell where he continued to be beaten. He describes the next day his body being covered with lumps and bruises. He and others were then required to kneel from 9 p.m. to 6 a.m. in their cell, with guards beating anyone who succumbed to fatigue and toppled over. They were denied access to bathrooms. Bright lights remained on for 24 hours a day. Prison officials repeatedly told Abrego-Garcia that they would transfer him to the cells containing gang members, who, they assured him, would tear him apart. He observed prisoners in nearby cells who he understood to be gang members violently harm each other without intervention from guards or personnel. Screams from nearby cells would ring out throughout the night without any response from prison guards or personnel. He lost 30 pounds in the course of 2 weeks, which I actually didn't know was even physically possible.
What is there to say about this? This is what the Trump administration has done to more than 200 other people. And again, there's a lot in MAGA world about these individuals being criminals and somehow they deserve it. But I just want to note that at least one of the individuals who's in CCOT is a young gay makeup artist, Andre Hernandez Romero. He was the one who cried out for his mother when he had his head shaved at CCOT. That was documented and then broadcast. Regardless of what you think of the individuals who the Trump administration is targeting, this is absolutely inhumane treatment, just absolutely shocking and inhumane treatment.
And just as a reminder, in addition to Romero, the Cato Institute research that we have talked about on this podcast makes a very compelling case that a tiny subset of this 200 plus population has any kind of documented criminal history or even immigration infractions.
They have tattoos. And that seems to be
the whole case against most of them.
Yeah. They have tattoos and they are brown.
Which, again, if you were wondering how this administration was going to go about enforcing its immigration policy, I think racial profiling, tattoo profiling is pretty much the answer. And think about where that goes.
And this is the administration that this Supreme Court insists on treating as any other, as just a regular administration, while granting them a seemingly ever-expanding set of powers.
The presumption of regularity is quite broad.
Yeah. As we've said, this term has been a long one, so we thought we'd play a mashup of some of the memorable moments from oral arguments over the last term as a look back at warp speed. So are you ready for it? Here we go.
Yeah, the book has a clear message. And a lot of people think it's a good message, and maybe it is a good message, but it's a message that a lot of people who hold on to traditional religious beliefs don't agree with. I don't think anybody can read that and say, well, this is just telling children that there are occasions when men marry other men. Uncle Bobby gets married to his boyfriend Jamie, and everybody's happy, and everything is, it portrays this. Everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this.
So Pride Puppy was the book that was used for the pre-kindergarten curriculum. That's no longer in the curriculum.
That's the one where they are supposed to look for the leather and things and bondage, things like that.
It's not bondage. It's a woman in a leather.
Sex worker, right?
No, that's not correct. No.
I read it.
It's a drag queen.
Drag queen and drag queen.
The leather that they're pointing to is a woman in a leather jacket, and one of the words is drag queen in the search.
And they're supposed to look for those.
It is an option at the end of the book, correct?
Yeah, okay.
All the religious school is saying is don't exclude us on account of our religion. I mean, if you go and apply to be a charter school and you're an environmental studies school, or you're a science-based school, or you're a Chinese immersion school, or you're a English grammar-focused school, you can get in. And then you come in and you say, oh, we're a religious school. It's like, oh, no, can't do that. That's too much. That's scary. We're not going to do that. And our cases have made very clear, and I think those are some of the most important cases we've had, of saying you can't treat religious people and religious institutions and religious speech as second class in the United States. And when you have a program that's open to all comers except religion, no, we can't do that. We can do everything else. That seems like rank discrimination against religion. And that's the concern that I think you need to deal with here.
So one of the parties here is the owner of Pornhub, right?
Yes.
And what percentage of the material on that is not obscene as to children?
Well, Your Honor, if we're talking about the youngest minors, I would agree that most of it is, and that is how we read the law.
Is it like the old Playboy magazine? You have essays there by the modern-day equivalent of Gore Vidal and William F. Buckley, Jr.?
Not in that sense.
All right, let's go down to what's the second most popular porn site?
Your Honor, I don't have the.
You don't know you represent these people.
What the school district has said, which is what Monahan said,
you believe that Mr. Martinez and the Solicitor General are lying?
Is that your an oral argument? Yes, absolutely. It is not true that we.
You should be more careful with your words.
Okay, well, they should be more careful in mischaracterizing a position.
Ms.
But-
Blatt,
yeah.
I confess I'm still troubled by your suggestion that your friends on the other side have lied.
Okay, let's pull it out.
Yeah, I think we're going to have to here. And I'd ask you to reconsider that phrase.
An oral argument.
If I might.
Was incorrect.
Incorrect is fine.
Well, lying.
People make mistakes.
Okay.
You can accuse people of being incorrect, but
That's
lying,
fine.
Ms. Blatt, if I might finish.
Sure.
Lying is another matter. One can interpret those perhaps different ways,
Well-
but surely a reasonable person could interpret them as arguing for a special rule in the educational context, correct?
No, only because of the
Ms.
text.
Blatt.
Okay, well,
A reasonable person, all of those emphasize the unique context of primary and secondary education and the need for a special rule, don't they?
fine, but what I'm objecting to.
Fine.
Can
Then would you withdraw your accusation?
I'll withdraw it.
Thank you. That's
Okay.
it.
And the government doesn't care about that. I mean, the government is fine with you doing that. You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
I agree, but then the question I would ask if the government said that, which I think kind of in the reply brief, maybe the government does say that, is that how on earth are you then serving a national security interest? You know, if all you're doing is just saying, we don't like a foreign country rearranging cat and dance videos, like, it's hard to come in and make a national security argument.
That's your best argument, is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But that's true of every search engine. I mean, you can take any of these algorithms, whether it's X or whether it's, you name it. What are the new ones? Blue Sky? I mean, none of these are apparent, right? You get what you get and you think that's puzzling. And
I mean, I don't know if I guess the pool is probably not deep enough for her to get crushed in it, but the gravity is dragging her down in the pool. There's an internal process going on in her body whereby her life is sucked away from her. I apologize, I'm not a doctor. I couldn't quite tell you what happens with asphyxiation, but the body's going to be attacking itself there, gasping for air, eventually die.
I'm just going to ask you to put yourself in a different frame of mind. Hard to do. Assume something you won't want to assume. But the assumption that I want you to make is that on the merits, which of course you did not take to this court, on the merits you are wrong, that the EO is unlawful. And I want to ask you, if we assume that, how do we get to that result on your view of the rules?
It is very difficult for me to attempt the hypothetical, but I will.
You know, I think that that's the important question in this case. Let's just assume you're dead wrong.
I think assume you're dead wrong is an apt place to let this term recapped rest. So we're out.
That's probably right, although the detailed graphic description of drowning also really spoke to me.
Eric Fagan was describing the experience of the last term for so many of us.
Yes, and he didn't even know it.
Nope.
Closing thoughts, any?
This was grim as fuck.
Yeah.
Yeah.
I mean, maybe a closing thought is a looking forward thought, which is this was so grim, and next term is also going to be insane, if anything, even crazier. So between the transgender athletes case, the Voting Rights Act re-argument that we've mentioned already, the huge campaign finance case, possible return of birthright citizenship, and the constitutional challenge to independent agencies, in addition to all of the many shadow docket cases, which again, as Vladik reminds us, the court is still sitting on a bunch of. So it's not like we get to rest and recharge until October. This is going to be a crazy summer and then an even crazier term. And let me just throw into the mix that depending on how the political landscape develops over the course of the next 6-9 months, there is a very real possibility of retirement announcements. I would think
Fantastico!
By January, I would, if I had to guess, because if the Senate map looks like it might result in the Democrats attaining a Senate majority, one or both of Alito or Thomas, I think, will very likely announce.
Justice Eileen Cannon or Emile Beauvais. Oh my gosh, the next year.
Okay, highlights. We need a positive note.
Okay, I will do a positive note and play the role of Kate Shaw, given the bleakness that Kate just offered us. So
we've turned Kate. We've turned her.
It's been a few terms now. I think I have been turned.
No, Kate, you were trying valiantly to stay in the light, but we brought you down. Leah and I got our hooks into you, and we made you dark.
Well, and I mean,
as
so
a
did
peace
Sam
offering,
Alito.
as a peace offering, last week the Wisconsin Supreme Court issued their much-awaited decision on whether the state's 1800s abortion ban, complete and total abortion ban, remains in effect in the Badger State. The progressive majority on the Wisconsin Supreme Court said that the state's 1800s era abortion ban is not in effect because the Wisconsin legislature effectively repealed that flat-out ban by creating a comprehensive set of regulations on abortion. So as a result, that prohibition on abortion not going to go into effect and allows abortion access to exist in the Badger State. Wanted to highlight not just the great majority opinion by Justice Rebecca Dallett, but also a separate writing by now Chief Justice Jill Karofsky. And in Chief Justice Karofsky's concurrence, she has a section that is about honoring their lives and their stories, in which she names women who have died recently because of abortion restrictions: Candy Miller, Amber Thurman, Gisele Barnica. And she notes that not only should those women be alive today, but that their suffering and experiences were foretold by the suffering of women generations ago. And she talks about her great-grandmother, Julia Cowan, dying because she sought to obtain an abortion during an era when abortions were prohibited. So I think an extremely remarkable, powerful writing, and an outcome that also reminds us that courts can be better and they can do better if you fight for them.
And if you have the Chief Justice of our hearts actually serving on courts.
Nothing but respect for my Chief Justice, Jill Karofsky.
Amen.
All right, let's close up with some favorite things just to give people something to do over the summer. I'll start. One of my favorite things in the last couple of weeks was footnote 12 of Stanley versus City of Sanford, where the justice of my heart, Justice Ketanji Brown Jackson, dragged Neil Gorsuch for filth, calling his textual healing faithless and outcome determinative. So inject that into my veins. I'm just going to keep reading it over and over again. That is my ASMR, and I love it. I will also note that I really enjoyed Emily Bazelon and Matthias Schwartz's New York Times profile on Judge Amir Ali's first 7 months on the District of Columbia. I think it's always really interesting to think about how judges set up their chambers and sort of adapt to the project of being a new judge. And I think doing so in this particular moment was especially challenging. And I think this is a really good examination of those challenges and what that was like. Also want to recommend Linda Greenhouse's This is the Real Impact of the Supreme Court's Planned Parenthood Decision. That's an op-ed piece in the New York Times on Medina versus Planned Parenthood of South Atlantic. Really fantastic. And then finally, I will just note a note that I read, and the note is titled When Rational Basis Review Bit. It is featured in the Harvard Law Review, and it's a history of rational basis review that is tethered to a discussion of a Louisiana case in which a widow lost her job arranging flowers at a local grocery store because the state of Louisiana requires that such floral arranging be done by licensed florists. So it's a great piece just of legal history and a really wonderful piece of student writing. Regrettably, the student isn't identified, but I just wanted to highlight this as something that I really enjoyed reading.
So I have a slew of things. Several of them are term recaps. You know, it's not like I want to consume more content on the Supreme Court, but there's so much great writing being done about the moment we are in that I want to highlight a lot of it. So Steve Vladek's post at 1 First Street, which I've already mentioned, A New Kind of Judicial Supremacy, is, I think, just a terrific piece on Trump versus Casa and the context for the term. Ellie Mistal's piece in The Nation, Samuel Alito Takes Pride in Gay Bashing. Very pointed, powerful takedown of Mahmoud versus Taylor. Sherilyn Ifill's Sherilyn Eifel's post, A Court Without the Range, on Sherilyn's newsletter on Substack, also on Trump versus Costa. Kate, I loved your piece in the New York Times, A Culture of Disdain, the Supreme Court's actions speak louder than its words. Another recent piece I liked, Alexandra Petrai's in The Atlantic. With the big, beautiful bill, you can now sponsor a billionaire of your choosing. She moved to The Atlantic in case listeners weren't aware and were looking for her. In the slightly lighter fare, Andor Season 2 has just been a wonderful show to watch in the midst of rising fascism because it is about living under and resistance to fascism. Lord's recent album, I know it's...
What was that?
It's received mixed reviews.
I liked it.
So I also loved it. I love Current Affairs. I love Broken Glass. I love Shapeshifters. I really like the album. Like /Love, Donald Trump announcing Trump fragrances and the video announcement of the Trump fragrances, just the specter of the president hawking his perfume and the website gettrumpfragrances.com. I don't know.
Did you remember
Jimmy
that New York
Carter
Times
selling his peanut farm to TrumpFragrances.com? It really is just like the arc of decline of a once great nation. Sorry, Melissa, I interrupted you.
No, did you all read the New York Times story last year about how teenage boys or preteen boys are really into scent maxing?
Yes.
Or are they just they're really into cologne? And
yeah.
I think I would like to see how the teenage boy audience responds to Trump fragrances. I think this will really be telling. Are they truly red-pilled or are they still up for grabs if they say no to the Trump fragrances?
I know no one who owns it. I don't even know if you can actually get it yet, but I am sure it smells like trash. I am sure.
It smells like an
emolument
product.
Yep. No, our candles smell like emoluments, and those smell good. So this doesn't smell like that.
I did love our eucalyptus candle slapped so hard.
Exactly.
I love eucalyptus as a scent. It's just
this is not
favorite.
what that smells like.
It smelled like the inside of a private jet. So it was
that's true.
Like a Qatari private jet. It was amazing.
It's true. Yeah. I'm just going to make a few additional recommendations. One, Bob Bauer, I thought, had a really good piece in his Executive Functions Substack about the appalling decision by Paramount, the parent company of CBS, to settle the lawsuit filed by Trump because Trump didn't like the way 60 Minutes edited an interview with Kamala Harris before an election that Trump won.
Yeah.
No plausible legal theory of injury gives Trump any chance of winning, I don't think.
But the real politic of this is that CBS is looking for a buyer, and
they want to stay in the good graces of this administration, and it's a vile blow to the rule of law and to journalistic independence, and I'm glad that Bob was as unsparing as he was about it. A couple of other things. One, a study published last week in The Lancet about the monstrous human toll of the decision by Elon Musk, Doge, and the Trump administration to destroy USAID and the United States' foreign aid. So these researchers, there's 10 authors on the study, they estimate that if the current cuts continue until 2030, so that is just 5 years from now, up to 14 million people who otherwise would have lived will die, including over 4 million children. It is impossible to get your head around those numbers.
The party of life.
Yeah, exactly. I did want to mention the Times Book Review that includes Leah's book, which I guess doesn't like Mean Girl references, but is otherwise a fantastic review. And it was in the context of kind of a group review / recommendation of a number of SCOTUS books. The author of the review is Alexis Coe. The title of the piece was Great Books on American History and the Supreme Court, although I think the headline has changed. But it includes not just Leah's wonderful Lawless, but also Rebecca Nagel's By the Fire We Carry, Anthony Lewis's classic Gideon's Trumpet, Richard Kluger's classic Simple Justice. So kind of a good summer SCOTUS reading list if you are looking to go deep on various eras in the Supreme Court's history. And then 2 books I haven't read yet, but that will be out this fall, and I am beyond excited to read. So one is Erin Carmon's Unbearable, 5 Women and the Perils of Pregnancy in America, and the other is the Harvard historian Jill Lepore's We the People, A History of the U.S. Constitution. I love basically everything Lepore ever does, and I cannot wait to read that book.
Yeah, so I got an advanced reader copy of Erin's book. It is fabulous, and I will be plugging it when we do our Dobbs retrospective later this summer, and also look forward to hopefully discussing it with her on the podcast.
Awesome.
All right, before we go, listeners, let's take a beat to fill you in on what our plans are for the summer. I will be getting on a private jet with my emotional support billionaire to go to a fantastico location somewhere in Europe. I'm just kidding. We're going to be here. We're going to be doing lots of episodes. We probably will not be done with this Supreme Court beat because shadow dockets are going to shadow docket and we're going to be there. So just so you understand, over the summer and through the beginning of October, the Supreme Court doesn't hear oral argument. So there won't be any cases for the court to issue bad decisions in on the merits docket, at least for the summer. That doesn't mean they will not issue some terrible decisions on the shadow docket. So we are going to be covering that. There will still be legal news. We will be covering what the lower courts are going to do as they try valiantly to do their jobs with one hand tied behind their back. That's a whole different story. We'll also be covering what Article 2 will do now that they have been emboldened and facilitated and effectuated by Article 3. So this is all to say that we will still be in your ear holes with a combination of legal news. We'll also have some deep dives on books that we loved and certain evergreen topics that we think you would like to know about. So we are still going to have a hot, strict scrutiny summer, a very appropriate hot, strict scrutiny summer, and we hope that you will join us.
Just a quick note about the summer episodes, in part because it is the summer, there will be some episodes on which not all three of us might be hosting, but don't worry, we will return in full force once the new term begins, and there will be some episodes in which all three of us are on as well.
We have to have time for our emotional support billionaires.
Exactly.
Please understand.
They impose a lot of demands on us, and who are we to say no? So as we wrap, just want to say thank you to our listeners for supporting the show and making it possible amidst this hellscape when there are so many things to focus on and pay attention to. We really do appreciate you sharing your time with us. We loved the chance to meet a lot of you in New York and DC at our live shows this summer. We'll be in Chicago in October and other locales to be announced soon. So we really hope we have a chance to meet more of you in person soon.
So also in the spirit of closing, I will just make one final plug for my recently published book, Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Look, I wrote a book. I'm kind of proud of what I did. I enjoyed it, so I'm going to plug it. But I recognize that there is a moment to stop doing a lot of things. And that moment is probably now, at least until the paperback edition comes out. Although that might not stop me from noting things when the court does them that call to mind the book. But anyways.
It's your podcast, Leah. You don't have to stop.
Well.
Okay, housekeeping. Republicans in Congress just passed one of the cruelest and least popular pieces of legislation in history. It's going to kick millions of people off their health care so that billionaires and millionaires can get another massive tax break. Many House Republicans who voted in favor of this bill won in their states by slim margins, and they're up for re-election next year. We can vote them out and win back the House and stop future awful legislation of this sort and hold these individuals accountable. You can donate to Vote Save America's Take Back the House Fund to support must-win state House races next year. Just go to votesaveamerica.com/house for more. This was paid for by Vote Save America, and you can learn more at votesaveamerica.com. This ad has not been authorized by any candidate or candidates committee.
And one more summer reading alert. Amanda Lippman's new book, When We're in Charge, which you should know about because Leah had a great conversation with her on the pod a couple of months ago, is out now from Crooked Reads. It's a guidebook to leadership for the next generation from the founder of the wonderful organization Run for Something, and it's the newest release from Crooked's publishing imprint. When We're in Charge makes a great gift for new graduates, for friends celebrating a big promotion, or really anyone looking to up their beach reading game this summer. Plus, you can complete your book look with an accompanying tote if you head to crooked.com/store for the exclusive tote bundle. Or you can just head straight to crooked.com/books to get the book.